couple of things that Toby observed, mentioned, stated. You know, we do have a lot of exemptions to the Public Records Act. I don't believe any of them are required, are they? Aren't they discretionary?
Now, there are some that say thou shalt not disclose certain types of records.
Well, we ought to be aware of that. You don't always have to say you can't have this record because it's an exemption. And you know, there's no penalty against a public employee for releasing a record that might be exempt. At least not yet. And the same with an open meeting. There are exceptions. But the councils and commissions and boards don't have to follow those exemptions. There might be some exceptions, attorney-client negotiations or discussions when there truly is a pending lawsuit. The issue over the value of property when a public agency is discussing the purchase or the acquisition or the sale of property. There are some obvious ones to me, possibly to you, but they aren't really a matter of absolute requirement. How about attorney-client privilege, which the coalition, which we have been struggling with for some years, especially after the so-called Hangartner decision by the Supreme Court. Public attorneys now, in most cases, are on contract. They're private attorneys who contract their services to public entities. In our county, I believe the only exception right now is a prosecuting attorney who serves the county commissioners and the agencies within the county government at that level. I don't believe the PUD has a public attorney. I don't believe the city council has a public attorney. I believe he's hired. Other entities deal with their legal issues in similar fashion. Attorneys are there to counsel and advise, but there is little requirement, if any requirement, that a council or board must follow that advice. Now, it's at their peril that they don't, but they aren't absolutely required to follow an attorney's advice. So there are some ways that public official, public entities can at least look at this thing in a broader perspective than the sometimes narrow perspective that the legal community foists on them. And sometimes we as citizens almost do the same by, in some cases, unreasonable requests and unreasonable demands. There are no unreasonable requests from citizens. There are no unreasonable demands, but sitting as an elected official, you certainly may think there are. With Lynn Kessler's absence, we were able to enjoy Toby's complete presentation, I hope. Well, almost. Next, we have Tim Ford. I got to know Tim primarily as a committee member of the Sunshine Committee member, because Tim is the vice chair of our State Sunshine Committee. And by the way, Patience Roby is a member of that committee. Lynn Kessler is a member of that committee. Really, it's a committee that was intended to help the legislature undo some of the things it had done. And as I said earlier, not a single one of our recommendations so far has been adopted to the legislative process. Ironic, maybe, I'm a skeptic. Tim serves as Rob McKenna's ombudsman for access issues, government access issues. He is referred to as the Open Government Ombudsman, and he assists the public and state and local agencies with open government questions, training, policy, and in some cases litigation. Not that he litigates, but I think he advises either for or against the process. He was appointed by Attorney General Rob McKenna to serve on the Public Records Exemption Accountability Committee, which by reference is the Sunshine Committee. That committee continues to, at least we hope, next July, to consider, to continue considering the many exemptions to our Public Records Act. In addition, many of us saw Tim up in our neighborhood here because he ran for the State Court of Appeals a year and a half ago, 2008 election. Fortunately for us, in one regard, he didn't make it. And maybe unfortunately, in another regard, he didn't make it. Tim Ford.
Thank you. I always cringe when Frank mentions my failed election for the Court of Appeals, but be it as it may, I did enjoy coming up to Jefferson County and meeting people. And getting out of Olympia is perhaps the funnest part of my entire job. Olympia is populated with lawyers, lobbyists. Well, maybe I should stop there before I make any more mistakes. But I enjoy meeting people and helping people. It's perhaps the most rewarding part of my job, and I do quite a bit of it. I get hundreds, literally hundreds and hundreds, I think over 700 this year, requests for assistance, mostly from citizens, some from agencies, some from attorneys who represent agencies, and they're asking questions on how to interpret the Public Records Act. How do we interpret the Public Meetings Act? Is a meeting illegal? Is an email a public record? I get the range of questions from very simple to very sophisticated. And I probably apologize more than any other attorney in all of Olympia, because sometimes it takes me more than a couple days to get back to somebody. And I invariably apologize. But I do like this job quite a bit, because access to government is a very American thing. And it means a lot to people. They understand that if you can get access to government, you can hold your government accountable. In today's world, there's a lot that goes around on the internet, a lot of information that can help people get access to government through the internet, by email. And that's a good thing, but oftentimes it adds new questions to what is a public record. Is an email a public record? Is a personal email a public record? And these questions are not always answered by our existing laws. Our Public Records Act, which was adopted back in 1972, talked about what is a public record, and it was defined as a writing that relates to the conduct of government that is used or possessed by government or created by government. That's essentially the definition. Well, the definition in 1972 didn't include emails, and it hasn't been amended to include emails. The definition of a writing included punch cards. How many of you know what a punch card is? Raise your hand. All right. Well, back when I was in junior high school, we used punch cards, a whole stack of them, fed them into a computer, and would do one calculation. And in junior high school, the kids, if they didn't like you, they'd knock over your stack of index cards. You'd have to pick them up, rearrange them in order to complete your task in school. But how things have changed since 1972. And our laws do not adequately keep up with the progress of technology. And so Rob McKenna, when he was elected Attorney General back in 2004, he created my position as Open Government Ombudsman, because traditionally attorneys in the Attorney General's office represent state agencies. They're required to do that by law. They don't represent citizens or local governments. In rare cases they do, but only when required by statute. Generally they represent state agencies. So there was no one inside the Attorney General's office who you could call and ask a question: how do I interpret the Public Records Act? Am I entitled to this record? Am I entitled to attend a public meeting? When Rob created this position, there was an overwhelming flood of phone calls for assistance. And